Sam.
I'm ready to be wrong.
In a written contract, a landscape designer agreed to draw up plans and install a homeowner's new in-ground swimming pool. The homeowner agreed to pay the landscape designer $10,000 once the pool was installed. After the pool was installed, the homeowner believed in good faith that the landscape designer's plan was defective. The homeowner orally offered to pay the designer $5,000. Instead, in full settlement of his claims for defective design, the landscape designer orally agreed to that offer, even though the reasonable market value of his services was $10,000. The homeowner paid the landscape designer $5,000 pursuant to their agreement. The landscape designer later sued the homeowner for the remaining $5,000. Both parties agreed to a bench trial. In a preliminary finding, the court concluded that the landscape designer's plan did not contain any defects.
Homeowner gets plans drawn up from this landscape designer. They say these plans are flawed. Basically, they don't meet the homeowner's criteria, whatever that means.
Now that it's defective, I will offer you $5,000 in settlement of my defective claim. Paid the $5,000, and then the landscaper turned around and sued me for $5,000. Is the landscape designer likely to prevail in his claim against the homeowner for $5,000? A, yes, because the oral agreement to modify the original contract is not enforceable under the statute of frauds. B, yes, because the homeowner's payment of $5,000 cannot furnish consideration for the landscape designer's promise to surrender his claim. C, no, because the landscape designer's acceptance of the $5,000 constituted a novation. D, no, because the landscape designer's promise to accept the $5,000 was binding once the homeowner made the payment.
The homeowner paid the landscape designer $5,000. The landscaper agreed to that.
Orally.
Like, because it was an oral agreement, it doesn't feel like there was a binding action there.
Remember, oral contracts are still contracts.
I'm going to go with B.
Unfortunately, with 26% of students answering B is incorrect. The correct answer is D. Consideration means a bargain for exchange for promises, performances, or both. The exchange is bargained for, in turn, if each party's promise or performance induces the others. He paid the $5,000, thus it was binding.